My Lord, Honorable Chief Justice and Veteran Chief of the Sikkim Judicial Academy, Sri Achay Sachdeva, the Director General of Police, Sikkim, Achina Kundu Ma'am, the Vice Chancellor of the Sikkim National Law University, judicial officers, both senior judicial officers, serving judicial officers and trained judicial officers, police officers, very senior police officers, I can see all of them here, public prosecutors, few law students also I can see, our own team from the Chief Justice's Secretariat. Let me first once again thank my Lord the Honorable the Chief Justice for providing this platform to me. Well, let me tell you that this program was not only conceived by His Lordship, but His Lordship also ensured that it is conducted. He attended similar program. This is in fact a repeat of a program we had in sometime during March this year. And since we wanted a wider audience involving all criminal justice functionaries, including the public prosecutors also, my Lord was kind enough to direct that a repeat program with few updates be conducted as soon as possible, and that's how we all are here today. Well, last time the topic assigned to me was only laws relating to arrest and all. This time I too have been given a wider topic, but very important topics, because you know, when we talk about individual liberty, criminal justice system in a way curtails individual liberties also. Well, someone might be accused of an offense, whether rightly or even wrongly, but then law, once it is set into motion, has to take its course. Well, to start with, before we go into our constitutional provisions regarding individual liberty, safeguards against illegal arrests and all, well, let me tell you that the foundation of all these legal principles was laid, or at least codified, in a very remarkable document known as the Magna Carta, as back as in the year 1215. Well, you know the background, how it came into, how King John was in fact coerced, compelled to sign it. I'll just read out the relevant portion from it, relevant clause from it, which deals with individual liberty, just to set the tone. No free man is to be taken or imprisoned or disseized of his free tenement or of his liberties or free customs, or outlawed or exiled or in any way ruined, nor will we go against such a man or send against him save by lawful judgment of his peers or by the law of the land. To no one will we sell or deny of delay, right or justice. You can see the principles were laid, the foundation was laid as back as in 1215 and codified in this particular, in these words. Now, we know the accused, at least when the accused persons are brought before the court, they would have already been through few, I would say, tribulations. And of course, I'm not talking about our local police here. Whatever I'm saying today, whatever I will be presenting today, is on a wider, please take it to be on a wider scale. What I've done is I've taken 2 videos. Last time I had 3 videos, in fact. This time since I've been given only 1 hour, I have 2 videos. I want you to go through it properly, just to give you the feel of how an accused, once he comes into contact with the law enforcement agencies, is treated. And that will set the tone for what I'm going to present after that. Well, Mr. O.P. Om Prakash is from the High Court Registry, from the computer cadre. If you could play the 2 videos, very short videos.
Welcome back. 2 South Florida officers are charged after a rough arrest caught on camera.
So this video showing one of the officers punching a man who was already in handcuffs. Let's get right to local 10 News reporter Glenna Milberg live now where this happened. Glenna.
Now the Lord
You'll see there's video cameras all up the block. This is on surveillance. And the police department, a group of them were here doing good police work. And then there was some bad judgment. And then there was an attempt at a cover-up.
You see it there, right?
This is the evidence in a cover-up. An officer accused of spiriting away what he thinks is incriminating video images and equipment.
Thank you, Mr. OP. Well, as gory as it may seem, well, this is the police of one of the most developed countries in the world. This is how they behave. Isn't it a case of use of excessive force? That too at that particular, in a case where $20, a fake $20 note was supposed to have been given by him, tendered by him in the nearby departmental store. Well, it is a case of excessive force, and you know what happened after that, and even the movement, BLM, Black Lives Matter, actually started from here, from this incident. Well, this was only to set the tone for today. So police officers, when you use your powers, or let me say functions to arrest, you ought to be extra careful. Please don't use excessive force, and let arresting someone not be an issue of, not be a trophy or an ego issue. So you need to be careful while restraining someone. Please do not use excessive force. Well, now talking about arrest, you all know once someone is arrested, especially in a small state like Sikkim, it brings a lot of humiliation to not only that arrested person, but also to his family and other near and dear ones. Well, if it is of some interest to the judicial officers, I'll just go through one slide. Then next slide, the next one. Okay, I'll just read it out, and the young trainee judicial officers can tell me who, from which book I've quoted this. Others may not, because most of you have attended the last program, so you will be knowing. Yeah, I'll start from here. In the afternoon, I was removed to the central jail in Kannanur and caged in a cell. I was all by myself. Iron bars and stone walls talked to me mutely. A warden would occasionally pass that way. There was no latrine, with a sense of privacy, and one had to make do with the available facilities. In the loneliness of the prison cell, time stood still. The minutes would not move, and the hours slept with no duty to perform. The jail food, what all that I had, the days, once in a long while, were punctuated by brief interviews, once a week with close relatives. A low wall separated us, and a warden stood here as if some dangerous secret would be communicated. I had some plain paper with me and a pencil. I was drawing a rough blueprint of the house I had planned to build on a lovely plot I had bought before the police nabbed me. Somehow, the jail staff misconceived my rough draft in pencil as a plan to escape, and so the paper was taken away. During daytime, at night, plenty of bugs sprayed under the bed and sucked the blood, and at night, on top of the bug menace, came the mosquitoes winging, singing and stinging. So sleep was a feat, and this ordeal went on for days. Unquote. Can the trainee judicial officer say whose experience is being narrated here? In his own words. Very good, very good. That's very rare to come from young law graduates, young judicial officers. It was none other than, let me tell this to the police officers also, the legendary Justice V.R. Krishna Iyer was also arrested for some reason. It was more of a political reason at that point of time in Kerala. And these are the ordeals that he had to go through. And let me tell you, our jails, our hajats are still not very habitable. Well, some police stations, the DGP sir is here, some police stations, they may have good cells or hajats, but majority of the police stations still have cells or hajats which are in deplorable condition. Well, this was only to say the experience of a legend in law, Justice V.R. Krishna Iyer. Well, if you could go back, Mr. O.P. Now, like I said, when you arrest someone, it brings a lot of humiliation, not only to him, but to everyone who is associated with him. For example, if someone working in an organization is arrested, even the organization is put to shame. Well, in the words of Supreme Court, just to give you an idea, I'll just quote it from the oft-quoted case, Arnes Kumar, because the directions here are, I think, some police officers are even reluctant to arrest the accused persons because they have to follow certain guidelines or certain directions contained in this particular judgment. I'll just read it and then I'll also come to those directions of the Honorable Supreme Court. Arrest brings humiliation, curtails freedom and casts scars forever. Lawmakers know it, so also the police. This is a battle between the lawmakers and the police, and it seems that the police has not learnt its lesson. The lesson implicit and embodied in CRPC. It has not come out of its colonial image despite 6 decades of independence. And this is in 2014 that we are talking about. It is largely considered as a tool of harassment, oppression, and surely not considered a friend of public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by the courts, but has not yielded desired results. Power to arrest greatly contributes to its arrogance, so also the failure of the magistracy to check it. Not only this, the power of arrest is one of the lucrative sources of police corruption. Well, this may not be the case here. The attitude to arrest first and then proceed with the rest is despicable. It has become a handy tool to the police officers who lack sensitivity or act with oblique motive. Well, oblique motive, we are not attributing to anyone. But sensitivity. Sensitivity. This is the reason why my Lord, the Honorable the Chief Justice, has been insisting on having these kinds of programs to sensitize all of you on both sides, the bar, I'd say prosecutors, the bench, and the police officers. Sensitivity. I was a POCSO judge for a very long time. I had become mechanical. Every POCSO case I would deal with it in a mechanical manner. Of course, I was a senior judicial officer even till few years back. Mechanical. I had become insensitive to POCSO matters. And it was thanks to the Honorable High Court. After different seminars, programs and all, we, not only me, other special judges of POCSO, they too were sensitized. So this is the reason why we all have assembled here today. Now, talking about Arnes Kumar. Now we all know what happens when one is arrested. It could be a symbolic physical restraint, or if it's a dreaded or a serious offender, you may have to put something to constrain his movements. Well, when you produce the accused before the magistrate, now before you arrest the accused, like I said, you are not to think of it as your power to arrest. You are to think of it as your function under the Code of Criminal Procedure, now the BNSS. The problem is, once we think that this is my power, then it actually goes into one's head. So for this reason, I'll just skip few slides and straight away, Mr. O.P., if you could go to that power to arrest and function to arrest. Yes, and the next slide. Well, there are many judgments of the Honorable Supreme Court which clearly says power to arrest has to be read with the justification to make that arrest. It's more of a function. I'll refer to that judgment as well. Well, these are the words of not only the statesman of that time, but one of the former British Prime Ministers, Benjamin Disraeli. I just want you to go through it. Even if you take it to be your power to arrest, this is what you have to bear in mind. I repeat that all power is a trust, both for judicial officers, everyone. that we are accountable for its exercise, and Arnesh Kumar has made sure DK Basu, starting from DK Basu, then to Arnesh Kumar, then to Rini Johar, and now Satyendra Kumar, until it has been made sure that we all are accountable, not only one branch, that from the people and for the people all springs and all must exist or good. This has also been quoted in Rini Johar's case, which came after Arnesh Kumar's judgment. Well, since we have police inspectors here who actually effect the arrest, I would like you and the magistrates, both serving magistrates and the training magistrates, you have been through it, you've gone through it, you have read it maybe multiple times, but let us read together. How often do we get to read together? Mr. OP, could you go to that Arnesh Kumar's judgment? It's just a few paragraphs. And magistrates too need to be careful while dealing with it. I'll tell you why. Bottom mein Janus, go to the bottom. Last page, some directions there. No, Ali Mati, the Varki judgment. Yes, Ali Mati, yeah, para 11, okay. I'll just read it out from here. Our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily, and magistrates do not authorize detention casually and mechanically. Well, the problem these days is even some of the judicial officers has become a little prosecution minded. Individual liberty is kept in the backseat. For that, before I proceed further, I would request Mr. OP to go back to the slide so that I can make the point clear. Next slide, Ms. Anus. Next one. Next one. Next one. Okay. Now the magistrates, I remember Benoy sir used to do that, being the brilliant judicial officer that he is. While producing an accused before him, if he was not satisfied with the materials placed before him, and I can say this because I was the district judge there. Probably the matter came on revision or something, but it was withdrawn. Now, he would look into the materials. I don't know what the present magistrates are doing. Unless he was satisfied with the materials placed before him, he would not grant remand, whether PC or police custody or judicial custody. At least one judicial officer I can vouch for is right here, who is the next resource person. And very recently, and these are not my words, when you perform your functions, your judicial functions, not your social functions, your judicial functions, please make sure that you also muster the courage to say no. Just because someone has been arrested, don't go by what the media has been saying, don't go by media trial, don't go by sensitivity, it might be oversensitized. Please muster the courage to apply a judicial mind. That is why we all are wearing black robes and presiding over the courts. And these are the words of the Hon'ble Supreme Court, maybe recent in January this year. Courts to muster courage and exercise its discretion judiciously to grant or not to grant bail. Now, once they produce the accused before you with all materials in their case diaries, go through it, exercise your judicial mind, and only then order the remand, whether to police custody or to judicial custody. Mr. OP, please go back to that judgment, Arnesh Kumar judgment. Now, what does it say? In order to ensure what we have observed above, we give the following directions. First one is to the state government. All police officers be provided with a checklist. You have the checklist. I have personally seen the checklist. containing specified subclauses under section 41B so and so. Now these are offences which are not very grave or not of very serious magnitude. The police officers have forwarded the checklist duly filled and furnished the reasons and materials which necessitated the arrest, while producing the accused before the magistrate for further detention. Now I don't understand, and I had mentioned this in the last program also. You can always mention in the checklist, okay, we want him to be in custody because of these reasons. For example, if you detain a person or nab a person or arrest a person for contraband drugs in his possession or in his bag or whatever in his possession, obviously you are going to say in your checklist that given the nature of the offence, for example, and these are not no less quantities, they come in very high quantities. If it is for peddling, then the quantity is very high. If it is 1 or 2 drugs, then the courts or even the police officers may look into whether he is a consumer of that, whether he needs detoxification, rehabilitation, or he needs to be sent to the rehab. And that is why I think SADA also has that provision. If the person arrested is a consumer, is a junkie is not illegal, but is a consumer of drugs, abuses drugs, then the court may consider sending him for rehabilitation or first detoxification, treatment is the word they use there, and then for rehabilitation if need be. So you can always say in your checklist, given the quantity of drugs which were recovered from this accused, we need further time to investigate into the source of the drugs, and there is every possibility of him fleeing from justice if granted bail, whether regular bail or interim bail. I think no magistrate is going to deny you that custody for interrogation. So please ensure that your checklist, you need to apply your mind. Just going through the checklist, using it mechanically, filling it mechanically won't suffice. Please make sure that you give your reasons for applying for his further custody. Well, now, for the magistrates now. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. This is where I remember what Benoy sir used to do. Record his satisfaction. If he disagreed with the whatever data materials were placed before him by the police authorities, by the investigating officer, he would simply say, no, I think this is a fit case for bail, and he actually performed his judicial functions, his pious judicial functions. Well, now the problem, if you act mechanically, and we know some people have been acting very mechanically. Please go up a little, scroll down. Okay. Failure to comply with directions aforesaid. Both sides may note it very carefully. Failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before the High Court having territorial jurisdiction. Now I'll pause here for some time. Now maybe because of this particular direction, our police officers are reluctant to go for to arrest and seek custody, even those cases where custody is actually required. Well, I have given you the Guru Mantra for that through this platform. Give your reasons. Just because you don't like the accused's face doesn't mean that you will get custody. Satisfy the learned court, satisfy the learned magistrate. Well, for our dear magistrates also, authorizing detention without recording reasons as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the Honorable Appropriate High Court. You need to be very careful. You might have maybe 100, 150 cases to deal with on the same day, but you cannot You cannot, you ought not take individual liberty casually. Please ensure that you perform your pious judicial functions and not get into trouble unnecessarily. Okay, Mr. OP, I think you can go back to the slides now. Well, prison experience, I did not go further. We also spoke about what the Supreme Court, we also discussed about what the Honorable Supreme Court has been saying about arrests and all, its implications, ramifications. We also went through the experience of the legendary Justice V.R. Krishna Iyer. Then, well now, there's something I wanted. Okay, can you go to the same slide after that power and, yes. Well, I've also quoted few relevant clauses from the Magna Carta again. A free man is not to be immersed. Well, immersed, many would not be knowing, is where you only impose fine, not the custody. For a small offence, save in accordance with the manner of the offence, and for a major offence according to its magnitude. Well, let me tell you, we have seen cases for a simple theft case, 379 theft case, the accused is not granted bail at all. Till recently, that was the situation. It is only after Honorable High Court and Honorable Chief Justice has been seeking monthly reports that such cases have come down. Now, for a 379 case which involves few thousand rupees, accused are kept behind the bars for 6 months, 1 year, just because he is a Nepalese national, just because he is a Bangladeshi national. Well, if he is willing to produce a local surety, and even if not local surety, if he is already well rooted here, then why not? It's for the learned courts, learned magistrates to exercise their judicial discretion. So let arrest not be the rule, let it be, arrest and detention not be the rule, let it be an exception. Of course, if the offence is of serious magnitude, then you know what is to be done. Well, Mr. OP, you can go to the next slide now. Okay. Remand, briefly I discussed. You know, when the duration of custody is to be calculated or reckoned from, it is from the date of production before the magistrate. Earlier only High Court judgments were there. Now we also have a Supreme Court judgment. This would be helpful for the judicial officers. I leave it with the Academy, and our head librarian Sujata ma'am will send it to you through email. Well, default bail. Now, another matter of serious concern is when the accused, when the police is unable to file the charge sheet or the challan within the given time frame, and the accused applies for bail. Well, let me tell you, of course the judicial officers will be knowing, even to the police officers, let me tell you, it has been time and again said by the Honorable Supreme Court that once you fail to file the charge sheet within the given period of 60 days or 90 days, then an indefeasible right accrues in favor of the accused. There were instances, I remember, I have seen it, I have witnessed it. There were instances when the accused would file bail, seeking default bail, and the magistrate concerned would talk to the SP and tell the SP to file the charge sheet latest by, if not tomorrow, by today evening, just to frustrate that indefeasible right. Well, these tactics may not work now. Please be very careful. Even the accused are very conscious now. If a complaint to that regard comes to my lord, then, well, again law will take its course. So please be mindful of the fact that Default bail means that the accused has now has, because of your failure to file the charge sheet, of course, there are many genuine reasons. An indefeasible right has accrued on the accused. You cannot again try and nullify it or frustrate it by filing the charge sheet. Once he has filed the bail, if no charge sheet by then, even if you file the charge sheet after, let's say, by the end of the day, it won't work. His indefeasible right, he has already excised that right. And he has to be granted default bail. Well, in some cases what happens is, okay, 60 days or 90 days period would be over. The accused would not file pray for default bail. Now in that case, if you file the charge sheet and if he now files the bail, then the magistrates are not bound to grant him bail. It would not amount to default bail because the charge sheet now has already been filed and his indefeasible right which had accrued because of non-filing of that charge sheet within the statutory period is now exhausted. That is another thing which I wanted you to take note of. Well, we have discussed the humiliations and tribulations which a person goes through while being arrested, the different nuances of remand and default bail. I've just kept it short because I was given only 1 hour and there are other eminent speakers also after this, and the presentations would follow by personal interaction by the Hon'ble Chief Justice. Now let me, after having done with the magistrates and the police officers, let me come to the public prosecutors. Well, my first question would be, are our public prosecutors, and this is not confined to Sikkim, I am talking on a pan-India basis, are our public prosecutors actually performing their functions as per the law or as envisaged by the law? Well, the answer, you know the answer. Well, let me just take you through. There are many judgments on role of prosecutors, but a very young law scholar, in his article, which has been published in White Black Legal Law Journal, which is an international legal journal, he has talked about it in these lines. Now he says, and I thought it would be relevant, very succinctly put to the point, and in fact better than many judgments. Well, he says, the prosecuting officers in the criminal justice administration are not the pawns in the hands of the government. And don't act like one. They are required to play their role in an impartial and unbiased manner. Are we playing that role in that manner? The prosecutor has to represent the state, then the government. You are not to represent, you may have been appointed by the government until there is a separate directorate of prosecution. Even then appointment would be by the government. But you are not representing the government. You are representing the people, you are representing the state. That's why all these cases say state versus, it doesn't say government of Sikkim versus Hon'ble. It says state of Sikkim versus Hon'ble. If it's a private complaint versus so and so. So you are not representing the government. Oh, मेरा तो पूरा acquittal हुआ. My name has gone down. There are whispers in the corridors of power. That should not be a concern. Do your duty. That is the duty. He must be the defender of the cause of his client as efficiently and as effectively as possible. However, in the performance of his duties, it is an obligation on him to work in synchronization with the other wings of the criminal justice system, primarily the police, the investigative officers. The prosecution and investigation, no doubt, are the two different aspects of the criminal justice system. However, they sometimes lack coordination on investigative issues. Egos come in. I have seen that. Okay, that PP is asking for that. How can that PP ask for that? I am a senior investigating officer. Where was I? Their acts are independent of each other as the prosecution and investigation, no doubt, are the two different aspects of the criminal justice system. However, they sometimes lack coordination on investigative issues. Their acts are independent of each other as investigating work is outside the court, whereas the role of the prosecutor is inside the court. It is also true that they are interdependent, though independent but interdependent. You complement each other actually. Hence, they should act in harmonizing the things in the delivery of justice. Now, our public prosecutors, in SADA cases we have seen, simply acting as a post office. These are not my words, the Supreme Court has said in the next slide. We are not to act as mere post offices. Apply your mind. Judges to apply their judicial mind, prosecutors and lawyers to apply the legal mind. Please perform your functions independently of any extraneous considerations. You are not there to win a medal or a gold medal. Do your work. Just do your work. Well, the next slide, Mr. O.P. Now, one area of concern which we have seen is when our public prosecutors representing the so-called state apply for withdrawal of prosecution. Well, let me tell you, of course it is not you. You won't get up one morning and say that I want to withdraw that case. Obviously someone would instruct you to move the court for withdrawal of the prosecution for many genuine reasons. But then, when the offence is, let's say, under the Prevention of Corruption Act, when the offence is under these drug menace laws, when the offence is for POCSO related offences, sexual offences, offences against women, I think then our public prosecutors have to rise above the day. They have to be firm, tell the one who has been instigating on, goading them on withdrawing the prosecution, tell them, no, this is not possible. I have nothing to say in this. I will make my submissions, my legal submission, let the Honourable Court decide on it. Don't wait for your brownie points. Well, here, withdrawal of cases, and we have seen, I personally have dealt with many cases where the public prosecutor has sought for permission to withdraw the case. Some magistrates, we were told, would simply send it to the government. Very naive and very foolish on their part. Instead of dealing with the matter judicially in the court, we heard that some magistrate in the rank of Chief Judicial Magistrate sent it to the state government. That shows the level of knowledge that judicial officer has. That is very unfortunate. Well, these are the words of the Honourable Supreme Court. When withdrawal of cases, please apply your own legal, your independent mind. Now the Supreme Court says, public prosecutors cannot act like the post office, like I said earlier. Public prosecutors cannot act like the post office on behalf of the state government. He or she is required to act in good faith, has to peruse the materials on record and form an independent opinion that the withdrawal of the case would really serve the public interest. We are here to serve the public interest, not to serve our own interest, not to earn brownie points. An order of the government to the public prosecutors, I repeat, an order of the government to the public prosecutors in this regard is not binding on you public prosecutors. He she cannot remain oblivious to his lawful obligations under the code, now the BNSS. He is required to constantly remember his duty to the court as well as his duty to the collective, the beneficiaries, the public at large, the public interest, the interest of justice. So, my dear public prosecutors, act independently. use your legal mind and let the honorable courts use their judicial mind. Well, any other slides, Mr. Opi? All right, Jai Hind. Thank you very much. Thank you, madam.
Good morning, everyone. I thought it was afternoon, but it's still 11:30. With the permission of my Lord the Honorable the Chief Justice, I'd like to begin my presentation. I acknowledge the presence of, apart from the Honorable the Chief Justice, the Chief Guest for the program, the Guest of Honor, Mr. Akshay Sachdeva, the Director General of Police, Madam Kundu, the Vice Chancellor of Sikkim National Law University, Registrar General Mr. Prajwal Khatiwada, the Director of the Academy, Sri N.G. Sharma, my colleagues from the High Court, Mr. Suman Palden, Ms. Sunam Denka, Mr. Benoy Sharma, my colleagues in the District Court, Ms. Jyoti Kharka, Ms. Ranjita Pradhan, Ms. Jwala Thapa, Ms. Rohini Rai, my colleagues from the other districts, Ms. Subarna Rai, Mr. Kharka, Mr. Jagat Rai, Mr. Jabyam, Mr. Seseham Subba, my colleague in the Law Department, Mr. Chetri, the learned members of the bar, senior police officers, the other police officers, and the training magistrates. I am happy to be here to give my short presentation. I do not know what has happened here, but the topic that has been assigned is the mandatory guidelines and procedural directions regarding arrest, remand, and bail. Most of the time when you come here, it is only one-way discourse. And I'm sure that my friends here, you have a lot of questions, especially on this side, on arrest, not only on arrest, bail and remand, but on the other aspect of investigation and on criminal justice system. So let us take this opportunity which Honorable the Chief Justice has provided us a platform to interact, put your questions, we will try to answer. We have learned resource persons here, and most of all, we have our senior judges, we have our magistrates from all the districts who day in and day out, like you, deal in the courts when arrest, remand and bail are concerned. So please feel free to ask your questions so that we can have an interactive session as well. Now the law regarding arrest, remand and bail, these are conceptually different. But when we talk about it, it intermingles, and we cannot talk about one without referring to the other. It is almost like a chronological order. When there is an arrest, there would be or would not be remand, and if there is a remand, there certainly would be an application for bail. After my colleague here spoke about this matter, I felt that I have very little to talk about, but I will try to make an endeavor. And I agree and I support what my colleague here said, is that what we need to understand And what we have gathered here is not to learn but to sensitize ourselves on these vital aspects, because life and personal liberty is the most valuable right of any human being. If you do not have life and personal liberty, then the other rights, I think, becomes meaningless. Article 21 is therefore one of the important articles of the Constitution of India. And for the purpose of this discourse, Article 22 of the Constitution of India, wherever there is arrest and remand. Now, why do we need this kind of sensitization is we could see from the pictures or the video that was palpable. Because in a country of ours, we have one side the might of the state, the muscle of the police, and on the other side we have the public. And what we are required to do is we are required to balance so that the scales do not go on one side or too much. Too much support to the police might will lead to a state where there is an anarchy, and at the same time there are these antisocial elements in the society who take advantage. And that is the time when the courts have the duty to rise and then balance the scale. From time immemorial, if you see the history in India and elsewhere, that's the reason why Magna Carta came to a country like England. Which country, I think, had covered I think more than half of the globe at that point of time and later. But even a country like England had to frame a charter like Magna Carta to protect the human rights of these citizens there. And India is not an exception. We have been having this kind of indiscriminate arrest. For what reasons? Number one, political reasons. Number two, extraneous circumstances. And number three, let me tell you this very frankly, it is also because of an individual's ego. I do not like this person, arrest him. The moment you get an opportunity, arrest that person. And that we've been seeing more often whenever there is an individual, a member of the public speaking up. Could be from the media, could be from social welfare organizations, NGOs. Whenever they speak up, and mostly they speak up against whom? Naturally it becomes the state. And in order to curb the voice, what we normally see, which you and me, we know very well, is that there is arrest, and most of the time there is illegal arrest. And that is the reason why I think, as far as 1994, even the Hon'ble Supreme Court, in this particular case of Joginder Kumar, said that to arrest is one thing, but you really need to arrest is another thing. You need to look into the case. You need to introspect and answer this question, do you really need to arrest? And the same question, later I will refer to the same judgment my brother here referred to, Arnish Kumar, asks the same question. Why do we need to arrest? Do we really need it? And this particular case of Joginder Kumar is vital, it's important. You know the reason why? My personal opinion is that this particular case set out the law in motion so far as what should be the law regarding arrest. Later in time, you will see that an amendment, a major amendment came to the Criminal Procedure Code then in 2009, which incorporated these guidelines. You may not say guidelines, but these words, these wise words of the Honorable Supreme Court of India, then Justice Venkatacharya, if I have not mistaken. This is a matter like we've discussed on earlier occasion as well, where a lawyer is taken into custody for several days. His whereabouts are not known. The family goes, the brother goes from one place to another, and then finally there is this habeas corpus application filed before the Honorable Supreme Court of India. And at that time, the Honorable Supreme Court of India had an opportunity to pass this judgment, and later in time, it was incorporated by the 2009 amendment as Section 40, Section 41, Section 41A, which is much talked about at the present time. This is one vital judgment which I'd like to request all the participants here to please go through. There were two aspects. Arrests should not be made routinely, and a person should be informed about their arrest. Now this second portion has come into our statute book as Section 47 of the present BNSS. If you see Article 22 of the Constitution of India, it also provides, Clause 1, that you should give information to the other party as to why he is arrested. Now, perhaps I have it in a later slide, but let me take it forward from here as to why do we need to inform that person as to why he has been arrested. D.K. Basu versus State of West Bengal is another matter where a series of guidelines, the series of orders were given by the Honorable Supreme Court of India, and one was whoever will arrest will wear a name tag of your particular name. You will inform the arrestee, the person arrested, on what grounds he has been arrested. You will inform the nearest family member of that person, and you will also put it in the GD book of your police station. Now these are certain guidelines which was in D.K. Basu, but this particular provision of 47 of BNSS has come into the attention of the Honorable Supreme Court of India on several occasions. And in one, the Honorable Supreme Court of India has said that if you do not give a proper information of the ground of his arrest, mandated under 47 of BNSS, that will be one ground of bail. That will be one ground where the magistrate will deny remand. And that will be one ground where the accused will have the right to be released on bail. So what I'm trying to say is that, my brothers and sisters here, when you arrest, it is not that arrest is not required at all. I fully agree that arrest is required, but at the same time, the idea is that there should be some reason, and there should be a solid reason for taking that man into custody and for denying his liberty. And when you do that, you have to keep in mind what 47 of BNSS says. Give that person the information as to why he was arrested. just read it in the morning. I was reading an order of the Hon'ble Calcutta High Court, where there is a much hyped case about a law student from Symbiosis Law College making some hate speech online, and she is arrested by Calcutta police from Gurgaon. Now she is brought here. The Hon'ble Calcutta High Court, in the vacation bench, takes up that matter, I think it was yesterday, and passes an order, interim bail, but not under the provision of the BNSS, but under writ jurisdiction. Now the Hon'ble Calcutta High Court, in the same order, has taken the picture of a form, which is a standard form for West Bengal Police, prepared under 47 of BNSS, as to the information that you need to give to the opposite party, to the arrestee, the person arrested or his family. Now in that particular form, what I saw is that the reasons for arrest is only mentioned that warrant of WA or a warrant of arrest has been issued against you from Alipur Court, CJM. And that is all. The Honorable Supreme Court time and again has said that these cryptic information will not suffice. And it does not take even 2 minutes or 5 minutes of your time just to mention you've been arrested. Let's say, for example, this case, that you've been arrested for a complaint lodged by, let's say in this case, Rashidi Foundation of Calcutta for hate speech against one community, one religious community to the other. Now that is an information which you can give it there itself. But if you just mention that warrant of arrest has been issued against you, that will not suffice. And that was one reason why I think the Honorable High Court of Calcutta just yesterday released this law student. One of the factors, I will not say the only factor, but one of the factors why she was released on interim bail. Now moving ahead, I will not take very long because I will keep some time for question and answer if there is any. And I'm sure you have questions. Now, so far as the arrest is concerned, this is the provision. You all know this. I don't need to tell you that how an arrest is done, how is it effected, so on and so forth. But these are the coordinate sections of law in CRPC vis-a-vis the BNSS. Now it starts with 35 of the present BNSS, which is the law in vogue. Now, the police officer, why I am trying to put this and why I have reproduced this from the law book is that time and again there has been, I think, quite a lot of questions from the police and also the magistrates here as to why remand is not given, or how is remand to be given, and what procedure are we to follow. Now the simple answer is refer to 35. Now 35 here is a replica of 41 and 41A together. Now the difference is that in CRPC it was two. Section 41 for arrest, section 41A, which came later, has to serve the notice if the punishment is less than 7 years. It has been clubbed together and made into 35. Now what does 35 say? Is that it is not that you do not have the right to arrest at all wherever there is a punishment which is less than 7 years. That is not the law. But the protection that gives here is a culmination of all these orders and judgments of the Honorable Supreme Court to safeguard personal liberty and to avoid unnecessary arrest. Now what it says is, if you want to arrest without a warrant, it can be done if a cognizable offence is committed in your presence. A. Don't read it together with B. This is disjunctively. B. There is a complaint and you are satisfied that this complaint is reasonable and he has committed an offence for a term less than 7 years. Now this was 41A earlier. What satisfaction do you have to, what is the satisfaction that the police officer should have is, number one, you have a reason to believe on the basis of that particular information or complaint that that person has committed the offence, and together with this you'll have to be satisfied that the arrest is necessary. I put this deliberately in italics so as to give an impression that the arrest is necessary. Number one, for what? To prevent that person from committing any further offence. Please note that these provisions from A to E, which I will come in the next slide, these are vital. And this is the same provision that you have to put it in your checklist. And if you cannot explain this provision clearly, then it is very difficult for the magistrates to order remand. And it will be very easy for the superior courts, or the writ courts, to strike out the arrest as well as remand. And that is the reason why I am saying, number A, what you have to do is you have to be satisfied that it is necessary to prevent that person from committing further offence. B, you need it for proper investigation. Now proper investigation could be a vague term. One may say that I need for this proper investigation, the other may say that I may need for this proper investigation, but the law requires that you have to give reasons. Why do we require? We require it for proper investigation, but for what proper investigation? You can't just say in your checklist, proper investigation. You have to supplement it with your materials. C, you want to prevent causing disappearance or tampering with evidence. If there is a necessity, yes. D, you want to prevent that person from dissuading or threatening or inducing the persons from coming to the court or going to the investigating agency to give evidence or disclosing such facts. And E, if you don't arrest, then you cannot ensure that his presence can be made in the court. These are vital, these are very important, and as I said, you have to supplement these with reasons. And it continues further. You will have to record in writing as to why you are making the arrest, and also with reasons. And if you are not making an arrest, also give reason why you are not making an arrest. Now, what we need to do is we need to sometimes unlearn things. At times what we have it in our mind is there is an offense, let's say theft. I was just reading here, brushing up with my memory, theft, 7 years, 379, or let's say 380, theft in a house, 380 of the old IPC, 7 years. If there is a robbery, 7 years. What do? You require to make an arrest sometimes. Or if you think that you do not require to make an arrest, you need to give your reasons. But our mindset is that there is a theft, you pick it up, you pick up the suspect, we need for questioning. That is all. Now what we need to understand is the paperwork that we do what we are trying to do, from the investigating agencies side, what I have seen is the paperwork is very less. They are in action. Perhaps they don't have time. Could be many factors, but it is important. Keep your paperwork proper. Give reasons. And like my colleague here said, there will be no single magistrate, I think, at least in our state, who will not grant remand if you give a proper reason as to why the arrest is necessary and why is remand necessary. Now, for example, in a theft case, there is a theft in a house, the CCTV camera shows this man entering into this. Perhaps he's wearing a cap or a hat, carrying a bag, but you zoom it closer and you can see that face, you can see it properly. When you bring for remand, why don't you bring that CCTV camera footage along? I know. Bring it along. All you need to do is take it in a pen drive, show it. Right now we have all the facilities in the courtroom. We have the TVs, we have everything there. Show it. This is the reason why we need. And what he has done is he has entered into this house, and sir, in his hand, can you see that bag, a trolley? That is one of the article that is mentioned in the FIR. VIP trolley, pink color. And inside this trolley we had these articles. Now what the investigating agency is required to do is that they require to recover these articles. Now the standard procedure is that they question. And once you question, there is a statement under 27. I do not know whether it is voluntary or involuntary, but there is a statement and there is a recovery of these articles. Now you require it for a recovery. But if there is no remand at all, how are you going to question? Within 24 hours, most of the time, it may not be possible. In a place like ours, I am being very practical, where we have less number of investigating agencies in the police stations, where the investigating officers, apart from their investigation work, are required to do other work as well. So this is the time where it is not possible to complete your investigation within 24 hours and then not take remand. Most of the time you want remand for 2 days or 3 days. At least you want to question, you want to recover, you want to connect the other facts together. And if you can give these reasons, I am sure that there will not be any application, or there will not be the situation where you have to be sad that no remand is given at all, despite our best effort. We have gone from here to here, and then finally arrested this man, but there is no remand at all. The hands of a magistrate is also tied. You have to keep that in mind. If there is no reasons for providing these information. Now, 35 subsection 3 or clause 3 includes what 41A was in the Code of Criminal Procedure. Now, what it requires is you require to give notice if it is less than 7 years, and you think that arrest is not required within that parameters that I was talking about. 4 and 5, these are things which were already there as a part of 41A, and I will come now directly to Arnesh Kumar. Now in Arnesh Kumar, these are laws laid down under 141 of the Constitution, and it is binding on every court within the territory of India. So Arnesh Kumar is one judgment where the Honorable Supreme Court has said that you give your reasons in writing. It has made reference to 41, which is now 35 of the BNSS, and it says, I have not mentioned which paragraph, but it says in pith and core, in substance, what you require is you must answer this question: why arrest? Go back in time into 94, what Joginder Kumar said. Why arrest? Only because the law gives you this power. Should you arrest? These are the questions that you have to put it to yourselves. Is it really required? What purpose will it serve? And what object will it achieve? And only if you answer these questions, then you can go forward and arrest that person. Otherwise, the answer is no. Because the bail, arrest and remand jurisprudence developed over time in India is bail and no jail. And that is the criminal jurisprudence developed here in our country. So that is the reason why you have to answer these questions very well. Now, what does the magistrates have to do? There is a mandate on the magistrate as well that you have to follow these guidelines. And if it is produced before a magistrate, the police officer is required to give your facts, reasons, and conclusion for arrest. I have put it in a blue color. This is not my words, this is the words of the Hon'ble Supreme Court in that particular judgment. It is said that it is only thereafter that the magistrate will authorize detention of the accused on remand. Now, these are things which has already been covered. I will not go into it. And though I have repeated it, this should not be done mechanically. Now, the directions of the Hon'ble Supreme Court there was, please instruct that automatic arrest should not be there. Give a checklist. Now, checklist was from E to E of 35 BNSS now, which was then 41. But please put into that checklist, supplement with your reasons for arrest. All right? You have to forward it to the magistrates along with materials, magistrate authorizing detention. You'll have to peruse these reports. Decisions not to arrest. It has to be communicated within 2 weeks with a copy to SP. Notice for appearance under 41A to be served. These are, I'm not reading it because it's here. You can please go through it quickly, and so that we can go to the other slide. And this is the particular case that I was talking about of section 47 of BNSS. This is SCC Online, Supreme Court, 269. That if 47 is not followed, that will give a right to bail. Now, Satinder Kumar Antil is another case which supplements what Arnish Kumar has already said. And in Satinder Kumar Antil, the order, you'll find it in this particular order of the 11th July 2022, that number one may not be very important right now, but number two, you'll have to keep in mind that you'll have to comply with 41A and 41 of the code, which now is 35 of BNSS. It reiterates that any dereliction have to be brought to the notice of the higher authority, and the courts, that means the magistrates, will have to be satisfied that there has been a compliance of 41 and 41A. Any non-compliance will entitle that person to be released on bail. So these are the words. Now these are different matters. Amandeep Singh Johar sir has already taken up this matter, where there is an SOP thereafter by Delhi Police. This is a judgment of the Honorable Delhi High Court. strict compliance of the judgment laid down in Siddharth. Now Siddharth is a different matter before the Hon'ble Supreme Court, where the case was under, where the magistrate in Delhi did not want to take cognizance of a matter when there was sufficient evidence and the investigating agency wanted to file the report. Under 170, the magistrate there did not take cognizance. The matter went up to the High Court. The High Court said, arrest is not required. The reason why the magistrate did not want to take cognizance was because the person is not arrested at all. So this travelled to the Honourable Supreme Court in the matter of Siddharth, where the Honourable Supreme Court said that arrest is not required at all. So the magistrates, whenever there is sufficient evidence and whenever these files come to the courts, are duty bound to take cognizance without insisting that there has to be an arrest of this person. Now the other direction was these things which you can just read it, I'll not take much time. What is important is that bail applications have to be disposed of within 2 weeks. Now why was this put also? It was because that there was pendency of a lot of bail matters all over the country, where even after filing bail applications, it was being kept months after months before the application actually becomes. It frustrates the entire proceedings, especially when it is under anticipatory bail jurisdiction. A person apprehends that he is arrested or he would be arrested in a particular matter. 438 was the old section. And then you file an application before a jurisdictional court, sessions court. But if you keep that matter pending for weeks and weeks together, and that person is arrested, it frustrates that entire application. And that is the reason I think the Honourable Supreme Court had to put it in words here as a directive that please complete it within 2 weeks. Now, why I was referring to and why was Sir referring to Arnesh Kumar is that Arnesh Kumar has been referred in this Satyendra Kumar Antil's matter as well, followed by the not very recent but 2023 judgment of this particular case, where the Honourable Supreme Court said, please follow the laws laid down in Arnesh Kumar. Give directions to all the Director General of Police to instruct that these directions are issued and followed. Circulars, etc. It's quite here. I think it's quite hot and humid here. Now, I will come to another slide of default bail, which has been covered by my colleague here. Is 167 of the old code, which we are familiar with, and 187 of the new BNSS. Now, why is this important is because 167 is the provision which lays down as to how remand is to be regulated. When a person is arrested, 40, 41, these are different aspects, 35 of the BNSS. Now you want remand. You have gone through the entire procedure prescribed, and then you have got a remand. Now the law regulates that remand is to be done in this particular manner. For the magistrates, first remand, the person has to be produced physically. It is not there in the old code, but the new BNSS mentions that thereafter, for judicial custody, you can have it through video conferencing as well. But for the first remand, police remand, physical production, and thereafter on every police remand, there has to be physical production of the accused in order to ensure the well-being of that person so that the person is all right. So this is the aspect of 187. And like Sir said, you will get the inherent right to bail if the charge sheet is not filed within 60 days or 90 days as the case may be. Now, questions may come up from the investigating agencies as to why is this person released? The crime is heinous. Now the law is that we don't consider merit. When you take up an application for default bail, merit is not considered at all, because it becomes an inherent right. And an inherent right has accrued upon that person, and he is entitled to this bail. These are the judgments that if you want to note down. And like Sir said, how do you calculate it? From the first remand, from the day of the first remand, and not from the date of arrest. How do you compute 90 or 60 days? You should exclude one day on which the charge sheet is filed. This is the particular case that if you want you can take it down. And when a charge sheet is filed and a bail application is filed on the same day, you are not entitled to this default bail. These are something like capsules. I'm putting it one after another because of the paucity of time and so that I can have some interaction. Now, can there be automatic release in default 60 days or 90 days? The answer is this. The accused must file a bail application to get this particular relief. Now, I have come almost to the end. Now, what remains is the bail jurisdiction, and bail, as you know, is a security. And normally the rule, like you said, like we all have said, is bail and no jail. And I can remember, I think I've told earlier as well, Justice Krishna Iyer, in his heydays, when he was a member of one political party, while he was arrested, he wrote a memoir, and he says that one day in jail is almost like 100 days outside, you know. So that is the plight which Sir most lucidly explained to us. The mosquitoes biting, you don't get a single minute's sleep. And these are the sorrow or the plight of a person arrested and put behind bar. So, on bail jurisdiction, my brothers and sisters here and the learned public prosecutors up there can note that this is one case where the Honorable Supreme Court has said that it is not punitive. And the Honorable Supreme Court has also gone to say, don't look into what public says. You know, there are certain bail applications, objections at times, that it gives a wrong message to the society. Yeah? Because if it is a matter of right, then what public says or these many people says should not be a consideration when liberty of a citizen is involved. The primary purpose is to secure that when he comes before the court to face the trial. Another case I'll just run it through is Gurbaksh, CBI, often quoted in our courts, but just as as a review, you can just take a note of this. These are also certain mandates, the mandatory guidelines laid down by the Honorable Supreme Court. And the other one is Sitaram. This is 2011. These are the factors to be considered while granting bail. And last but not the least, this is a directive of the Honorable Supreme Court. Wherever there is a bail, there is an email or an application which has been devised known as FASTA. As soon as there is a bail, it goes via email to the jail, and the release can be facilitated as soon as possible, and at times with the intervention of our district legal services authority committee. Now that is all I have to say. Thank you all, and I will be happy if you have any questions.
From Crime Branch, Gangtok.
Right, sir.
So my question is, sir, suppose a crime has been committed here in Gangtok, sir.
Yes.
And I've sent a notice and a 41A notice. I've sent it to the accused. So can he file an anticipatory bail in Mumbai and get an anticipatory bail from there, sir?
Possible, sir. It is possible that an anticipatory bail can be filed at that place where the accused stays. I don't remember this case. I think our Registrar here normally quotes this matter. But it is possible that an anticipatory bail can be filed in other jurisdiction as well.
So without finding anything about the case, so the other High Court jurisdiction can provide anticipatory bail to the accused, sir?
I would like to interrupt here.
Yes, sir.
Because what this police officer has raised is a question of his apprehension based on jurisdiction. So the fundamental concept of where jurisdiction of the court can be exercised is of paramount consideration. The concept of anticipatory bail is a sort of preemptive protection given by a court of competent jurisdiction. Now, the gentleman police officer has issued some notice under some provision of law from Gangtok. The clever person that the notice is now in Bombay. The only ground that he has to show before the Bombay court is, I may be picked up from here, because obviously Sikkim will not be able to exercise jurisdiction over Bombay, but Sikkim will make a request to the jurisdictional law and order authority within Maharashtra, where could you please switch off that? Band karo usko. So the thing is, the fundamental question is, where will I likely to be affected if I am arrested? So the question was, why can it be in Bombay? The answer is yes, which you said. But the reason is that he will say that I will be arrested from here. He need not have to travel to Sikkim to get arrested. He will be then arrested from that jurisdiction in Bombay, and on a transit remand be brought to his jurisdiction. So the jurisdictional question would be answered by a simple one-line statement made in the bail application that I am likely to face an arrest here. Here would be the local jurisdiction. And that is the reason why the court will consider whether to grant anticipatory or not grant anticipatory is a matter that is not the question which is asked. Jurisdiction.
Yes, this is the answer that you have received. Because the jurisdiction is entirely different. Under 438 is anticipatory bail jurisdiction, and 437 or 439 of the old code gives the other aspect of the bail. Yes, sir.
So my intention was not to arrest him. That is why I sent him a notice. So then he applied for anticipatory bail in the Mumbai High Court. Sir.
Your intention may not be known to him.
Sir.
What is required is his apprehension. If he apprehends that he will be arrested, and of course, a person in Bombay, Mumbai or Delhi or down south have never come to Sikkim, would have various kind of ideas of what Sikkim is, or what police would be here. Perhaps he may be of that impression that he would be arrested. So that is his apprehension. And if he is able to satisfy the court there, then anticipatory bail.
The other thing that now transpires is the officer says that my intention was not to arrest him. So to put it clearly that if his object is not to arrest him, the effect of notice is not neutralized by the order of granting him protection of anticipatory bail. Anticipatory bail would be that if he is arrested, he would be immediately brought before the local magistrate and released. But that does not prevent this person from answering to that notice.
Yes.
The notice never gets stayed. So by way of clarification to the officer who is from the back, who is very important, is there should not be a confusion between the two. One is whether we are proceeding to arrest him. The answer is that no, there was no intention to arrest him. However, having secured an order granting the accused protection from arrest does not ipso facto mean that the person has been restrained or is being protected from giving an answer to his notice.
Absolutely.
Sir, suppose if that person doesn't comply to the notice, now the anticipatory bail has already been granted by the Mumbai High Court. So what should be my course of action in this, sir?
Most of the time, one of the ground or one of the condition is that you are getting an anticipatory bail, but that does not prevent the investigating agency to question him. And if he doesn't comply with your notice, you are at liberty to make an application before the same court saying that there is a violation.
And in addition to that, the order of anticipatory bail itself will have some conditions attached to it.
Yes.
In one of those conditions that he will comply with the directions of the IO from time to time. There is rarely a blanket anticipatory bail order I have seen, which says that, bail will be granted, you don't have to comply with summons or directions.
Absolutely.
No, that cannot be so. If that kind of order is passed, then you have to go up to the Supreme Court and get that order set aside. But if it is an order of giving him protection from arrest, there will be caveats attached to those orders. Much very clearly it will say, that order will say that subject to the condition that he will be available before the IO as and when required,
Yes.
or he will give answers to whatever queries the IO may raise from time to time. He will visit so and so police station as and when required. So there cannot be a blanket order. If that kind of an order is made, that order can be immediately recalled or set aside.
Correct. There will always be some conditions. Whenever there is an order of anticipatory bail, at the end, the learned judge writes that in the event of arrest, this person will be released on furnishing, let's say, bond of this amount, subject to that he complies with the investigating agency's request of answering the summons or notice. Yes?
Now, since the High Court in Mumbai, so they have set aside some conditions, okay, so that he has to go to the IO and visit whenever the IO calls him. So in this case, suppose he doesn't comply with the notice, then do we have the authority to arrest him, or we have to challenge that order first, then only we can do the things?
It is always desirable to inform the Honorable Court there
Sir.
that the orders passed by you have not been complied with, and let the law take its own course.
But we cannot take action directly without informing the court, right, sir?
You have to inform the court.
Sir. Thank you, sir.
Yes. Or perhaps my brother here is waiting for his turn. I will not delay any further, and your further questions, we will take it up after Mr. Benoy completes his presentation. Thank you, sir. Thank you.
Good afternoon to all. Very good afternoon to Honorable the Chief Justice, the Director General of Police, the participants, the learned judicial officers, new trainee judicial officers, public prosecutors, probably defense lawyer, one or two maybe, and everyone. With the permission of the chair, I would like to bring in my session today. The topic that I have been given is investigation, loopholes and reform strategies. It was a big topic. It can cover a lot vast places in the criminal law, but I tried to remain within the bounds of my time as well as the necessity of this program, keeping in mind the participants. Contents that I would be covering, there were sub-contents in this topic like adoption of best practices for the investigation, improved coordination between stakeholders, promotion of speedy and fair trial proceeding. So this would be the brief idea that I'll be taking you all through the next 45 minutes of this session. Now, we were all actually, I heard my predecessor speakers, we must keep in mind that we are dealing in this criminal law with a human being and not an animal. That is very important to keep in mind, because often at places, if not everywhere, the investigating side and the judicial side may take different views as to a particular offense. Let's take, for example, drugs. The judicial side would always stick to the law. It does not mean that the judges would like to see the offenders go away scot-free in drugs cases. It is not that the judges are not concerned about the society, but we all have our roles to play. We may be the wheels of the same chariot, but the function somewhere may be overlapping insofar as the ultimate concern of both the sides is justice. Somewhere we may differ in how we approach these situations, and more of it, the police officers are more in contact with the society at the first place on the ground, rather than judicial officers, because at times, in fact many of the times, we do maintain social aloofness. It does not mean that we are not with the society. We are performing our duty, and wherever necessary, the constitutional courts have passed so many judgments which concern the society in PIL or under writ jurisdiction. So we all head towards the same direction, but of course at times we may be having a different route to take when it comes to offenses. And as I said, we are dealing with a human being which has a brain. The only strength a human has over animal is his brain. In all other aspects, if you see, it's the animal which does more than what we can do. So on that aspect, there is always a psychological side when it comes to human. It's not that we may always be judging, or police officers may always be arresting. Sometimes we may be in the other side of the law, knowingly, unknowingly, probably unintentionally, because we are not supposed to take law on our hands, being the law officers. When we are wrong, we look for justice. We shout and say, I have been wrong. There must be justice. But at times the very same person may be on the other side. And when we do the wrong, we look for compromise. Oh, let's settle it, come on. It's a human nature to, just like you see in social media, when two vehicles collide, the one which has the more damage always thinks he is the victim. It could be the other side also, right? So the perspective differs when we are dealing with humans. So let's be clear about that at first. So the major concern that comes to especially to the police is that the conviction rate is very, very low. It's not only in Sikkim but in the entire country. Barring POCSO cases, I think in the state of Sikkim, in other offences the conviction is hardly seen. In fact, to be frank, when I used to sit as a magistrate and when there was a conviction, I used to get dizziness. Certain kind of natural response, I couldn't explain it myself that as to why I got that dizziness. Literally, I used to get dizziness whenever I was pronouncing a conviction judgment. Perhaps so many acquittal judgments was a routine one. It's a routine case that judgments are acquittal. In fact, at the time of charge itself, we get to know whether the case is going to get acquitted. But the law says that we have to frame charge before charge in consideration of the materials that are before us. So we proceed on. So what leads to this? Is it procedural complexities? Yes, at some point, especially in drugs and psychotropic cases, NDPS cases. Still the cases reach up to the Honorable Supreme Court on the very simple matter of seizure and all. The law still doesn't get settled. Time and again, even the coordinate benches raise doubt on the procedure adopted or the legality or the legal pronouncement on the subject, and it is usually referred to the larger benches, which takes long time to settle. Of course, in these cases, I would say there are certain procedural complexities, especially in this statutes relating to drugs. So that might confuse a police officer as to what his steps should be in such cases. Another one could be inadequate police training. The world has moved on. We have forensic science that has come on, and the methods of investigation has changed. But are those changes have arrived in our jurisdiction? That's a question which may have to be dealt internally by the police team. We cannot say that there is an 100% absolute training, and we cannot say that each and every IO is expert in investigation. Limited resources, and this is also a factual aspect. The resources available before the police department may be too meager to consider the development, the changes that is to be brought in the police investigation, their system, which includes their not only the investigation, which also includes their well-being. I believe that a person would work well if he has all the facilities provided. Lack of forensic facilities, absolutely. Just today morning I was talking with Judicial whether the RFSL has gone to any improvement beyond when I was there in 2019 at Gangtok as a CJ. So I said there have been certain appointments of directors and all, but I still believe, and it was confirmed that there is still no DNA test at RFSL, a regional forensic science laboratory, a huge name. In fact, when yesterday I tried to research on RFSL, I couldn't even find a website of that particular institution. I went to the Home Department website under whose control the RFSL is situated, because I wanted to look into certain details, what facilities it is providing. I couldn't get, except the advertisement for post of directors and all, in PDF form somewhere electronically saved, and the Google could give me only that. So, yes, lack of forensic facilities too can lead to acquittals. Understaffed policing system, yes, yesterday I was just looking into, there ought to be, as per the standard, 100 police officers per 10,000 of population, but I think that's well below that's the Indian ratio. So understaffed policing system puts a strain on the investigating side and the side which maintains the law and order, which may be a primary job of the police functionaries. This also I do not know this answer could be with the police officers better, but we cannot have a system devoid of this. The political, superior or powerful interference that may come into investigation. The IO would be stuck, and to be very frank, the IO is just a rank of sub-inspector. Sometimes SHO or police inspector, except in some special cases where the DSP or the superintendent of police will be investigating. So we cannot deny the existence of this factor too, which may lead to acquittals. Now, existence of any or all of these factors lead to a weakened investigation and a consequential acquittal, unless there is a miracle. Like POCSO Act, where the reverse burden is on the accused, right? And NI Act too. Now, proper and adequate investigation is a hallmark of fair trial. We have sat as judges, my colleagues are here, my juniors are here. You know, the investigation is so important to the court that it can make or break the case. Judge does have a power under 311A, the erstwhile 311A CRPC, where to, you know, for the ends of justice, the court can exercise its power. But those are limited. The court cannot go down to the field and investigate and collect evidence and come. The whole trial depends on the evidence that is brought before the court. And some, you know, space remains for the judge to call for the evidence and etc. But that is too meek and also contested heavily by the defense side. So without a fair or a proper investigation, a fair trial is impossible. And the complainant are the people, you know, it is this police officers or the state representing that particular victim. The victim, I personally would feel that there should have been provisions in the Code of Criminal Procedure or the BNSS, the latest one, where victims should have some kind of say in the investigation, but they have hardly any place where they can go to say. The domain of investigation is totally with the investigating officers. Somewhere the courts do have power, including the magisterial courts, much more power with the constitutional courts, but that takes time for a victim to go file a petition, a direction from the court for proper investigation, and all that takes a lot of time. And usually it would be a headache for a victim to seek that redressal process. The only place they can go is police. What has happened to my case? And if there is no satisfactory answer, that would cause more harm to the complainant or the victim. Now let me begin with the journey of how police begins after the FIR is registered. First, they would visit the crime scene. IO has to reach to the place of occurrence. There some people would have been gathered, right? Then there is an interaction of the IO with the people there. And recording 161, now it's 180, recording of statement, so that the IO can come back with whatever he heard and saw from that place of occurrence. Now usually I have found in cases this is done only once. I do not know the reason why. There is no bar in law visiting the crime scene again and again, examining the witnesses again and again till you are satisfied as to what had actually occurred. And the statement is usually a one-page, A4 size. And onto the contrary, if you sponsor the accused or the witnesses to speak before a magistrate under the erstwhile 164 CRPC, their statements would be 2 or 3 pages, because the magistrate would be inquiring into, after that, where did you go? Then what happened? Because the magistrate sits there to see that some kind of thing comes for the case, right? Actually, it would be even more better if we are not required to read the 161. That might, lead us to some other place to ask leading questions. To be fair enough, I think we can just ask the witnesses as to what has happened and what went on. And the 164 statements are usually longer than the 161 statements, which actually has to be opposite in my view. So I've never seen a case, except a few vigilance cases, where the statement of witnesses have been taken twice, when I needed some more information for the person. But in all the criminal cases, I have seen it once. And that's the end of it, the job done. So that's why I said the travel for this purpose can be to and fro. There's no bar in it. Because the purpose of recording 161 is not a formality, it is for you to know what the person is saying and what had happened, so that you can come back home, recollect on it. It should be in the case diary. And you can read it, and you can, because investigation requires application of mind. You just can't, you have to think as to what may have happened as well. The second thing which I have seen is the problem with the seizures that usually affects the cases in the trial courts. Now, of course, seizure witnesses not helping the prosecution case is a usual affair. Of course, there are a lot of stock witnesses, and when I used to interact with the IOs as a magistrate, they used to say that it's so difficult to get witnesses. Though there is a provision for punishing the person who refuses to stay as a witness on the direction of the police officer, that's a disobedience to lawful orders of a police officer. However, that would be going too extreme every time to do that, right? So it's not that court would disbelieve the stock witnesses also every time, but they are usually doubted. So each case has its own facts, and the court, there's no any presumption that once a stock witness would be disbelieved every time by the court, but of course they are looked with suspicion by the court. In a small place like Sikkim, yes, we have, it's usually the same witnesses who usually volunteer to sit as seizure witnesses. Those are coming, who are nearby police stations or known to the SHO as a co-villager there or somehow, and who would listen to the SHO, so they would be readily willing to sit as a seizure witness. They usually destroy the case because they would only come and say, I don't know anything, it was the IO who made me sign and I signed it. Usually that is also resorted to. But the actual seizure process is like IO reaches the place of occurrence, you find the weapon of offense or any object there which is relatable to your case, you need to seize it there and there. And whoever is present there, and you should make a witness. But if you come back to the police station after bringing the weapon of offense and asking someone else to come later on to the police station, it may be the same person who was in the place of occurrence, but he will definitely say this was not seized at the place. He will maintain that truth. And it's difficult for a witness during cross-examination to stand the test of cross-examination if he has lied. So most of the stock witnesses are aware that what questions would they be asked during cross-examination, so they will try to speak the truth in the chief examination that yes, I stood as a seizure witness but at the police station. That is usually resorted to. There could be many factors why IO would do that, including engagement into some other works and etc. That is more easier actually, instead of preparing it at the place of occurrence. But if you see this section, any police officer may seize, now it's 106, I think it was 102 earlier, 2 or 3. Any police officer may seize any property which may be alleged or suspected to have been stolen or which may be found. It is usually the second part of the definition which covers the cases, or which may be found under circumstances which create suspicion of the commission of any offense. In fact, there are judicial pronouncements which says witnesses are required in this section. Of course, witnesses would be, if witnesses are kept to the seizure, they would fortify the case of the prosecution. But this section nowhere says a witness is required, unless another section which says if it is a search of a closed place, the witnesses must be there and someone respectable from the society. That could be a legal problem whether witnesses are required or not during this seizure when you have just reached to the place of occurrence. If it's a jungle, no one is present there, you are required to seize the property there. And in a jungle, you may not find a witness. I, as a judge, may still believe the idea that yes, I seized this at the place of occurrence, jungle, and I didn't find any witnesses there, so I have kept no witnesses. There's no law which says that the IO should be seen with suspicion. But of course, now you are one of the parties that would be interested in the outcome of the case. The court will always be cautious regarding the evidence. But having kept the seizure witness, the problem comes is when you have kept a seizure witness, the court will see now this seizure witness will vouch for what you have done. But they doing otherwise leads the court to doubt the investigation process itself, because it was you who have kept the witnesses. So when you are keeping the witnesses, be careful that the person is not anyone who agrees to stand as a witness. Look for someone who can vouch for what the process you adopted during the seizure. Now, one more thing that is here which we can see is every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate. Has any IO report followed this process? Till I was there, no seizure was reported to the magistrate. And this is where case breaks. the defense always puts this question: have you reported it to the magistrate? This authenticates the chain of custody, and as well as the sincerity of the IO in showing that I seized the property at 8 o'clock today, and by 12 o'clock I've reported it to magistrate. The magistrate is a person who is sitting in the court. It's a judicial magistrate, and so much of it would fortify so much of your case regarding the seizure that any doubts that will be raised later on may be dispelled by the very fact that you have reported the seizure to the magistrate timely. This process is never complied by the investigating officers. I do not know the reason, except maybe in the drugs cases. And sometimes we have even seen that the material object is still in the police custody, police hazard, police malkhana, even though it is mentioned, submitted to the court in the charge sheet. Usually the magistrates do not go and peruse the materials down there in the malkhana. They would believe what is written in the charge sheet, the report. But then the court will have to call those materials, and the defense starts jumping that, oh, that cannot be relied, it's supplanted now. Of course, that affects a lot of your case. So, to dispel any doubts about what property has been seized, I think the IO should report to the concerned jurisdictional magistrate about the seizure, which the section says so, right? And the rest is not of much relevance out there. But the seized properties are always brought to the court when the charge sheet is filed. Now another 180, which was erstwhile 161, as I already described before, there is no bar in taking the statement of the witnesses twice or even more than that, subject to, of course, not asking the same questions again and again and bringing the same answers. It is to further the investigation that you may examine the witness twice or more than once. Now, one provision that has come about in this new law is, let's see that bold and underlined portion. It says that provided that statement made under this subsection may also be recorded by audio, video, electronic means. This may solve a lot of problem. First problem it would solve is IO need not recall what the witnesses said if he has not been reduced to writing immediately, because witness is not required to sign these statements, right? So it can be done by audio, video, electronic means, but I do not know, since it is in a proviso and not in the main section, I believe that this should be resorted to when absolutely essential. So this is one change that has been brought in the 161 statement by 180. Now I would see that the procedure for investigation has also been brought about a slight change by the new law. Now I do not know, this law says it is the SHO which should go to investigate or depute some other police officer under him. But SHO cannot investigate all the cases every time, otherwise he will be the only IO. So perhaps, but he has to give reasons for deputing someone else in this case. So I think that has to be adhered to by the SHO every time he can give. Of course, he will be having reasons for not investigating each and every case. Now this section brings about one of the changes as compared to the previous law, that the forensic examination becomes mandatory on receipt of every information relating to the commission of an offence which is made punishable for 7 years or more. In such cases, the officer in charge of a police station shall, from such date as may be notified within a period of 5 years by the state government. The state government has been given 5 years to notify this. In this regard, cause the forensic expert to visit the crime scene to collect forensic evidence in the offence, and also cause videography of the process on mobile phone or any other electronic device. The use of mobile phones are always challenged in the court. Probably that is the reason why the legislature expressly made the use of mobile phone permissible for videography as well. So a forensic examination becomes mandatory as the case may be. And mandatory in a sense, if the case really requires forensic evidence, then one has to send the forensic expert. If not, they may not. But that the state government has been given 5 years time to notify. I'm so sorry this is not reflected there, but I am reading the provision which I said. Within the 5 years time, the state government is to notify that this requirement of procedural law. It's under 175 B and SS, 176 sorry. Another thing that if you could see, this slide is not changing. The DNA contamination is another issue that the trial courts face. Usually when the reports are received from the forensic, it usually comes with that the sample sent was unworthy of examination, and therefore they could not opine on it. Now, it is not that you will find absolute sterile evidences. There will be material objects where there will be DNA of other people. But what this contamination is defined is as something which entered into that particular sample or an exhibit at or after the point when a controlled forensic process starts. So we do not have in our jurisdiction a controlled forensic requirement as to which area is to be cordoned. How many of people can enter into that cordoned area if left unchecked in offences, especially where the population is large. The crowd is already there before the police reaches. We even know the case of that Kolkata rape and murder case. The whole building was destroyed. There was an allegation that it was an attempt to destroy the evidence. But that, I think, did cause a lot of problem for the forensics, because people entering there and destroying the place, may have perhaps reduced all kind of evidences there. So there will be DNAs of other people in the material objects, but once the controlled forensic process starts, then it should not enter. And there are ways of doing it, because the natural transfers of DNA, just like I have done this book, it would be natural, right? My DNA may have transferred, or some of my previous speakers' DNA might have transferred out here. But once the control process starts, this should be minimized. Okay, so for that, one of the way is to use a barrier. By barrier, it means use of avoiding direct handling of the material without barrier, like use of gloves or any other material that could be there in this as prescribed by the standard operating procedure. Now, ignoring this standard operating procedure leads to the samples being unworthy of examination. And yesterday, just I was reading it, even the results of forensic can change because of the contamination, and due to ineffective use of test methods, a wrong result is a possibility. And more so, the contamination can also occur in the forensic lab. It has more chances, though the sterility there also needs to be taken care of, and the police should be well within the domain to request the forensic labs that such contamination should not take place. It would not be a first case. There are contamination in the forensic labs as well while handling the samples, and there are more chances because they are handling so many samples there. Now, it is also a necessity in forensic investigation that you cannot approach all the cases or the crime scenes with the same formula. Each crime of murder, it may require a different formula of forensic approach. The rape may require a different, sexual assault, may require a different approach, and theft may require a different approach. So you cannot have one framework for each case. That has to be determined in each and every case individually. So before forensic investigation, a clear framework for adoption in a particular case requiring forensic investigation is a must. Then only the crime scene needs to be entered by the IO or the forensic experts. Next problematic area which leads to acquittal in the trial courts is the non-establishment of chain of custody. Though it may not be looked into by the trial courts every time, but this is so vital because this is always challenged by the defense. There is not a single record as to how a particular material passed from the IO to the doctor or from the witness to the IO. And it could be as simple as birth certificate seizures. The courts have been, I would say, magnanimous not to consider this aspect that well when there are substantial evidences on record, including the Honorable Supreme Court, even in the latest judgments where they were appalled to see that the chain of custody records are not maintained, yet they have upheld the convictions of the accused persons on the ground that there are substantial evidence available to convict the accused. But I would say there is a clear case of warning from the courts. Now be careful with the aspect of chain of custody, otherwise one fine day we might not be able to come to your rescue on the basis of just substantial evidence, more so when the evidence is the electronic evidence or forensic evidences. So to maintain the chain of custody is very much important. The item is picked up, the IO puts it into the bag and he goes to the police station. Some of the police stations, I don't think they even have functional malkhana, if I am not wrong. A functional malkhana means a proper malkhana where things could be kept properly and not just a room. It is a basic necessity which must be adhered to maintain the authenticity of material object till produced before the court as a material to be proved for the purpose of a case. A good lawyer would tear the seizures and the travel of the material objects by using so many judgments on this. It's just because it's not challenged, the court would have not gone deeply into this. But yes, this is a requirement of law that a proper record of the passing of hands of the evidence has to be maintained and proved in the court of law. Now, we have often seen this in drugs cases. I have just kept my topic to the practical issues that I have seen in the police, often in the social media and with interaction with them. Now, this is a co-accused, especially in drugs cases, telling the police officer, it's not me, it's him. And as we all know, NDPS and SADA has it's like a formula for registering the case and then going to the place of occurrence, making seizures and all. It's almost like mathematics in this provisions, unlike CRPC. There were cases when the co-accused were arrested, but no any recovery has been made from the co-accused, just on the basis of the information given by one accused from whom the drugs were recovered. Now, what would be the position then? As we all know, the Indian Evidence Act and the present new law is clear about that no confession to a police officer can be proved in the court of law except so much of the information which leads to the discovery of a fact. That reads as, provided that when any fact is deposed to as discovered in consequences of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact discovered, may be proved. So this is the only uses of the statement made by the accused to the police officer. So let's move ahead a little bit. Is there anything else? Now I've never seen this section used in state of Sikkim. There's a similar section in NDPS Act as well, as well as Customs Act. The law stands clear as pronounced in the case of Tupan Singh versus State of Tamil Nadu recently, that the statement made by an accused under this section before a police officer or any officer, no mind you, any other officer authorized on this behalf by the central or state government under NDPS Act can also takes record statements of the accused persons, is inadmissible against the accused. So this is a constitutional bench judgment which was referred to when the coordinate benches differed. Of course, this judgment is by a 2:1 majority, yet the majority holds, and they have said, no, that is inadmissible, forget about it. You cannot prove it against the accused. Against the co-accused, now there are a lot of cases here where it's not only one person involved, probably, as per the police investigation. There are suppliers from Siliguri as well in drugs cases, from different places within the state of Sikkim. Now there are a lot of questions rising, what would be the jurisdictional course, right? A person, on the basis of information given by the accused here, for a case registered here, police are going to places like Siliguri and arresting person there, bringing it back to the Sikkim. And but when a legal question comes, then was anything recovered from it? If not, then it would be very difficult to sustain. Forget about the conviction, even the remand of the accused, because unless you have attached the section of vicarious liability, but that is rarely seen. Neither 34 section is there, neither 120B is there. That is the only way you can at that stage rope in the other accused from a different jurisdiction, though he may have participated from Siliguri, but to book him and to make him try before the court of Sikkim, 120B or 34 or any similar sections is essential to hold on to the accused. Otherwise, if you go by NDPS Act, there has to be an independent recovery from him. Otherwise, what did you get? Nothing. Just the person. So that is the law as it stands today. This is 67 if you have not gone through before. Any officer referred to in section 42, it includes police officer, revenue department officers or such other officers as empowered by the government. During the course of any inquiry in connection with the contravention of provisions of this act, call for information from any person for the purpose of satisfying himself whether there has been any contravention of the provisions of this act. Usually in other states, the statement of accused is recorded under this one, 67. Saying that they called for information from him and therefore they have recorded this. But we are still recording it under section 161 erstwhile of CRPC. Now another experience that I've seen as a magistrate is that there's an over-reliance on the statement of accused made in the custody by the police officers. In fact, that is the first thing that the police officers usually resort to in investigating the case. As we all know, these statements can only be used if there is a discovery of fact. Even if there is a discovery of the fact, court would look into it at the last as some sustaining material to convict the accused. So, but it's not a substantive piece of evidence. There is always a misconception among the police officers that what accused says in the custody is the final and such a proof that the court is going to take it as some kind of clinching evidence. No, that is not at all. It may be for the police officers investigating that, because the accused would confess even if it does before you. So you may be convinced of what he is saying, but the court would not be unless it is proved by other evidences. So I think there should not be over-reliance on custodial statement. This leads to the IO not looking into other evidences and not working hard to look for evidences on the other side, because we have this, we have recovered this. It is a very weak evidence. Is the same? So another one that we have seen in the trial courts is the test identification parade being done routinely. Sometimes it cuts the prosecution case itself if the person fails to identify the accused. So what is the purpose of this test identification? Here also the IOs have a misconception that if the witness identifies the person in test identification, then it's a clinching evidence against that person. This is even weaker than what was there in section 25, 26, 27 of Indian Evidence Act. Purpose for confirming the identity of the suspects. This is usually done, or as it began, to identify the suspects. Sometimes you have an FIR before you, naming a certain person. The witness, the victim or the complainant also do not know who is that person, right? And you try to locate the person. You have been showing to the complainant, is this the person? The complainant denies it. Now you find a person, right? And you want to confirm that this is the person who has committed the offense. Let's say in case of thefts, usually the thief would cover the faces or jump over the balcony and run away, but the victim or the complainant may have got a glimpse of the person. In such cases, test identification helps IO to confirm, yes, I've got the correct accused. Its job is done, finished. Now, if this is taken as something to prove the guilt of the accused in the court of law, I think the prosecuting agency is wasting your time. We even will not look at this. It may be a relevant fact under Section 7, but a very small one to connect the accused with some other evidence on record. So it does not serve a huge purpose, but what the police would think is that the victim and the accused are known to each other since years, and there's an application before a judicial magistrate or chief judicial magistrate to conduct the test identification period of the accused. The jail is about 12 kilometers from district court, and if there's a traffic jam, it would take around more than 1 hour sometime. It could be same with the other jurisdictions. And by the time the magistrate reaches there and questions the identifier, do you know the accused person? If you know when you have seen him last, he's just my co-villager. I've seen him since years. What's the point of test identification now? It makes no sense. And often, the senior police officers here, I've interacted on this with the IO when I was a magistrate. They would say, sir, if we go without this, our charge sheet does not pass through this level of deputy SP, because he questions why TIP was not done. So at the higher level, I think that the charge sheets are not being seen as something formally to be done, including 164 statement of witnesses. Those are tendered to be recorded routinely, even when the police knows that the witness would in the courtroom speak the truth. So 164 statement of witness, police tender such witnesses, sponsor for recording before the magistrate to so that even if he changes his statement in the court later on, you have something to put it to him and say, see, this is your statement. It merely acts as a corroborative. It's not a substantial evidence. So I've often heard from the IOs that if they file a charge sheet, even when there is no necessity to do TIP or 164 statement, it is rejected at the superior level, saying that no, you must do this, otherwise the court will think otherwise. That's not true. What court requires is the fact, even if it has been done wrongly, even if the procedure that has been followed may have been wrong, but what the court looks into the fact. A moment a doubt is created, the court starts doubting the case, and ultimately in the end, the prosecution has failed to prove the case beyond reasonable doubt, actually means this, right? So the senior officers are here, maybe that can be looked into. Those are genuine grievances of the IO. And more so in the police system, the directions of the superior, I think that is taken as something to be done. This is 164, now it's 183. Very less use of provision providing for recording the statement of an approver. In these drugs cases, I do not see why the person who was named by the co-accused is not sponsored as an approver. That is rarely done, and all the cases leads to acquittal. Or this approval, there are lots of cases before the police where you have no evidence apart from one person who seems to be complicit in the crime, right? He can be tendered as approver. Despite doing all the legal processes, if there is an acquittal, that is a legal acquittal. But you missing out the procedures and there being an acquittal, I think the blame comes to the investigating agency only. Lack of coordination between police and public prosecutor, of course, 100% I would say in our state, as far as my experience goes as a magistrate. In fact, when the remand cases were listed, the magistrate expects a public prosecutor to represent that remand, not the IO. IO, of course, IO would be in the courtrooms, but they would not be as well versed in law as are the PPs. So the court would have certain queries in the courtroom. Then when we ask to the IO, IO would not know that portion of the law. But public prosecutor is supposed to know that. But if I do not know how is the scenario now, in the remand, when the police come for remand, it is usually only the IO, Pesker and the judge in the courtroom. And defense lawyer, I do not know what's the name exactly, remand lawyer, who represents the accused. And there's no one to speak for the police. The defense on the other side would bring a lot of judgments saying that, including Ernest Kumar, now we all know, but still they would bring that judgment to convince the judge. But there would be no one to speak for the police. And the court cannot speak every time for the police, though we would look into the law, what is required. So there is an absolute no coordination between the police and the public prosecutor as far as I know. And I'll tell you, to bring this coordination, it was in the year 2018 somewhere when I was at Gangtok. I thought something must be done. So I asked my PP that, see, no, IO enters my courtroom for a remand without your presence. Then the PP said yes. Then later on, I respect those IOs who I could see standing in the door. We have got the news that no, this magistrate will not allow me inside without the prosecutor being there. My requirement was I needed to hear the prosecution because some remands were complicated. So later on, I would see I was standing on the door. I would ask my PESCO why they are not coming. So we got passed an order saying that they should not enter without the prosecutor, or at least the remand application should be initiated by the prosecutors, acknowledging there is a remand there in the courtroom. But there being no prosecutor, I said that okay, let the IO come now. The PP is not there. When I would search for, they would say she has already left. And remands usually come at the back end of the day. So then I told my PP the next day that why you did so. Now I'm empowering you that the IO should come through you for the remand applications so that there is a control over what is happening even at the stage. But they refused that. Then I had to leave that alone and ask the IO to come, and whatever he can speak, he would speak. So, and one of the reasons that they used to give me was if I do not know from where that came, if the police, IO and the PP would talk, then someone would say that you two are cooking up a case against the accused, somehow you are trying to produce evidence and what to say, in a manner that is not recognized in law. But I don't think that's what that we cannot stop that if it's happening or if it may happen for a particular case. But so they had that apprehension. I do not know from where it came. I did not know its source. They would say so. They would even say that there's judgment on that. I never read that judgment. Probably I thought they did not understand the ratio of the judgment. No high court would ever tell that police and public prosecutor cannot coordinate for doing justice. They may have said in a context where there was a hand in gloves to prove a case. That's different. So I never read that case. I never believed what they said. And I could not explain to them that could not be a case also. So extent of coordination, yeah, on this point. How far you go to coordinate? A prosecutor cannot become an IO and IO cannot become a prosecutor in the courtroom. So each will have to know its boundaries and respect each other's boundaries. But discussion on a certain matter, like remand, police would come, they would not know. Like Ernest Kumar problem is half of the problem from the prosecution side. If they would know that there cannot be remand on this case, they could have advised the police that remand can't be on this. Why to waste the time? The judge is bound to reject it. So the extent of coordination, I think on the law secretary also here, as well as the Director General of Police. What coordination needs to be there, and what is their extent? The people should be trained, the IOs and the people. How far I can go on this? That is missing in them. As a meaningful coordination is always required between the public prosecutor and the IO for the success of the case, genuine cases, and not cooking up evidences, etc. Now, in this case of Supreme Court, I may read what I said just now. In a criminal trial, the IO, the prosecutor, and the court play a very important role. The court's prime duty is to find out the truth. The IO, the prosecutor, and the courts must work in sync and ensure that the guilty are punished by bringing on record adequate, credible legal evidence. Now, by sync means what is the part of the powers of the police under CRPC. For the judges, 311, if an application seeking further evidence is filed by the prosecution, my sync would be allowing it if I see no bar to it. And usually courts are liberal in allowing all this. So this sync does not mean the sync behind the scenes, but sync in a proper legal manner. If the IO stumbles, the prosecutor must pull him up and take necessary steps to rectify the lacunae. The criminal court must be alert, it must oversee their actions, and in case it suspects foul play, it must use its vast powers and frustrate any attempt to set at naught a genuine prosecution. Contribution of judicial magistrate, monitoring investigation. There's a case called Abhinandan Jha, where the magistrate can monitor the investigation in certain circumstances. It's a long judgment, this can be read. Otherwise, there's a common conception that investigation is the domain of the police. Come and shut it down, I've got nothing to do, I'll be in trouble. No, if you can read this judgment, it shows what role you can do and what is your role during investigation. Forensic evidences, reports not coming to the court is another problem that leads to delay of the cases. But this is the same case, Joshinder Yadav, where the Honorable Supreme Court was furious with the FSL agencies and made this order. The concerned court must ask for explanation and must summon the concerned officer of the FSL to give an explanation as to why the viscera report is not forwarded to the investigating agency. Here the material was viscera, it could be any forensic material. The criminal court must ensure that it is brought on record. And my experience says that in one of the juvenile cases when the DNA was being delayed heavily by the FSL from Kolkata, ultimately when I resorted to this judgment, it came within the next 15 days. So it's not that, there are good people everywhere. If you remind the correct people by correct process, then your things might work. And one of the roles of the magistrates, which I think they overlook, is if you see 187(9), in a summons case, investigation has to be completed within 6 months of the arrest by the police. If not, then the investigation can be stopped. The objective to prevent minor cases from dragging on indefinitely. Right? You can see this section also. I've used this section as a CJ in Gangtok, and I think many of the magistrate IOs who are there may know that. But you must give a notice to the IO that why it is delayed. You have to hear the other side, definitely. And time can be extended with the permission of the magistrate. And how would you know this? You all have FIR with you all. Especially the CJM would have the diary of FIR in his court. You can just check in there which are those cases which are summons trial, where the charge sheet or final report has not come even beyond 6 months period. This delays unnecessary small cases, but ultimately in the courtroom, this prevents the unnecessary small cases from coming to the court, where the victims and accused ultimately would come with 320 applications before you saying kindly compound it. And one of the sections that the police would have put is non-compoundable, a bigger one, even though the FIR did not inform that one. Now this also causes a great delay. The person has to go to the Honorable High Court under 482 elsewhere to quash it. So I would also request the police that while putting sections in the FIR, let the genuine sections be put, not the biggest one, to see that if anything comes in the future, then this section will hold it. That is absolutely wrong to my understanding. It always begins with the biggest section, and whenever I've dealt such cases, a lot of cases, and about 12, not only one, about 10 or 12 big sections are put in there, and there are no materials. And when the question of bail comes, the judge will definitely ask the IO, did you find anything on this so far? The IO says no. Usually they say, and the court records it, and the IO gets a negative view from their superiors. I've seen this. You are just being fact. Yes, it's not there. It's not. They can't bring it from anywhere. Now, juvenile justice also is it different from the criminal trial? It's really different from the criminal trial. The juvenile justice system. It is not at all a court, not at all a IPC, not at all a CRPC. It is a different system. Now, one of the things in the JJ Act is that the inquiry begins as soon as the child is brought before the board, not when the charge sheet is filed. In fact, as far as I understand, no charge sheets or anything is required in juvenile justice cases. It has to be completed within 4 months. The moment the child is produced before the board, the inquiry begins, and it is the board that inquires. This is more of an inquisitorial system rather than adversarial, and the board can ask for the statements of the witnesses to the investigating officer, collate it, and make inquiry materials out of it. Juvenile can participate. There's no such concept of 313 or which I have usually seen. It does say, if you read the provision carefully, shall follow such procedure as may be prescribed, and subject thereto shall follow as far may be the procedure laid down in the code of CRPC. The ordinary procedure is as prescribed. There is no such prescription. We go by the laws and the rules. Summons trial procedure, it's only indicative that you can use this procedure so that you can be fair. You cannot adopt any unfair process on your own. So, usually we have seen that even these juvenile cases by the IOs are treated as the criminal trials. Of course, the society has its own view. There are some 16, 17-year-old child in conflict with law. They are still a child. We have to see them from the viewpoint of this law. The society might see it differently, but we have to stick to the procedure prescribed by the law. So in this case, I don't think, because even if you see the punishment is there in the JJ Act itself, not in the IPC. Now, this is my last point, and one of the new provision that has come in the new law is there can be a preliminary inquiry when an FIR is made before the SHO. This has a huge potential of misuse. There is already a hue and cry from the people that the police stations are not registered in the FIR. On top of that, the law has allowed preliminary investigation, whereas Lalita Kumari case had allowed it only in a very special cases. It was very restrictive. This has opened where the offence from 3 years to 7 years punishable. The police can go for preliminary inquiry and do it for 14 days and then register report. Now there might be a confusion between the police officers of this section and section 19 of POCSO Act. The POCSO Act is a special legislation. It overrides CRPC and it itself has its processes. There are certain offences in the POCSO Act which are punishable up to 7, I think sexual harassment, etc. In these cases, in my view, preliminary inquiry is prohibited. Actually, if I am to be asked, I would say that the synonym of section 154 previous CRPC in the POCSO Act is section 19 itself. It is recorded under this. Notwithstanding anything contained in the CRPC, when any information is given regarding the offence of POCSO or any offence likely to happen, then it must be recorded by the police officers. So in my view, this section 19 overrides the CRPC and there is no ground for preliminary investigation in special cases. So this has a police baton, a justice law. I think IOS should also take this law book and never forget it. Of course, I am not saying you forget it, but there are a lot of things. But we cannot leave law when it comes to trials, right? And I may remind everyone here that we are all bound by what we have said out here. So with this, I will thank you all for patient hearing. I think I forgot my time also. I thank you very much.